Good afternoon. I would like to offer all in attendance a very warm welcome to our ongoing symposium dealing with various tax matters. On behalf of the Quantum Tax Law Consortium, I'd like to start off by covering a few issues that we have been talking about in the last few minutes leading up to this program. Primarily over the last several months, we've been getting questions and we've been trying to deal with them. One of the questions we had is, well, when do you do an estate freeze? How is an estate freeze done? We've had a series on estate freezes. And then, of course, one of the subjects that invariably comes up whenever we talk about tax planning of any sort, either domestically or internationally, trusts are always a main subject, our main thrust. But some of the attendees, lawyers, accountants, and some business owners, executives in public companies have been asking us, please explain to us how trusts work. They're mystifying. We're intrigued by trusts, but how do they come into place? When does one use a trust? Well, first of all, I can appreciate their trusts are confusing. Some people look at them as a minefield. There's various different kinds of trusts. There's testamentary trusts, inter vivos trusts, insurance trusts, charitable trusts, bear trusts. There's trusts that are used for so many different reasons. And the level of understanding by most practitioners as well as business owners sometimes isn't sufficient to be able to plan with using trusts on a very specialized level. So as an example, perhaps a builder of who knows, could be a home builder, it could be a machine builder. Well, certainly they can build the best structures in the world, but at times they require engineers. Sometimes there's metallurgical issues. Everybody's aware of trusts. They're a tool that's well known. Software is well known. We're using software for our program today. All accountants and lawyers use software, I think, business owners alike. But if you were to think of trust as a tool that's common, like software, well, engineers sometimes use finite element analysis software, which allows them to be able to measure plasticity in order to bend steel, giving it the appropriate structural integrity. Also, elasticity is measured in order to ensure tensile strength. When individuals are looking at building machinery, well, there's issues involving velocity, lubricity, porosity, all sorts of issues that are very specialized that good builders, like good lawyers and good accountants, do every day. But some of these finer things behind the background are not part of the building. What home builder, what machine builder who's competent would not employ the use of a specialist, of an individual that has specialized knowledge in the area of metallurgical science when you're working with formation and deflection and all of these different things? Of course they would. There's a building code for building structures. There's a thickness of wall cavities. There's the positioning of supporting walls and all of that. And those are the things that are kind of at times looked at behind the scenes, but give an incredible amount of importance. And just like those kinds of things, and by the way, for you lawyers and accountants in attendance, I would suggest that, and I've said this before, but clients tend, and I'm talking to the clients too, tend to put accountants particularly in an unfair position. They expect them to know everything about tax, and that is unfair. And essentially, it's not the trusts themselves that are bewildering or create mystery. It's the proper use of trusts. So what is it about trusts that creates intrigue? Is it because we're interested in passing our companies on to the next generation or introducing family members as shareholders? Is it because we want to protect our assets in case of a family law dispute inside of a family? Is it because we're concerned about a liability claim if somebody sues us for some other reason? Other than liking the idea of a trust because the idea of a trust might be sexy, is there any other reason that you are intrigued by trust? Because that's what we're hearing. We're hearing that it is something. So, okay, let's start off by saying, we'll start thinking about this and we'll start drilling down. And we're going to be introducing our expert panel. And I think all of the attendees today many of you may not have been with us before, but essentially, I'll just make a brief introduction for those of you who don't know the members of our expert panel. We have Michael Meller, who's my partner in quantum tax law litigator with more than 40 years experience. Lorne Saltman. Lorne is the head of the tax group at Gardiner Roberts. He's also counsel to quantum tax law. Of course, we have John McLeod. And John is known not only in Canada, but internationally as a foremost expert in trust and is the chairman of Eticas Group and used to be the head of a very large division for RBC. And basically, we have in our group, as always, we try to have some of the top people, both in Canada and internationally, as subject matter experts. And so when we think about it, and as we start going through it, you know, we have these great builders. Why am I thinking of a builder? Why am I using an analogy like that? Well, your lawyers and accountants are helping you to build structures where you can promote your business and advance your wealth and sleep at night. Isn't that great? Nothing can replace that. We're not here to replace your existing lawyers or your accountants. But what we're here to do is to help at this point to demystify a subject that causes a lot of confusion. And this panel today will be helpful to you, whether you're an accountant or a lawyer or a business owner, to help to better understand some of these salient points. So what we'll do is we'll talk a little bit about the use of trust, the history of trust. We're going to be talking about foreign trusts as well, and some of the hazards that we have to be concerned about. But before we get into all of that, I want to just touch on some of the basics. And if Jeremy, you can go to the next slide just for a minute, please. No, yeah, there we go. So in Canada, and we've talked about this before, as much as we love living here, all right, and as much as it's a great place to live in every way, Canada has adopted legislation from way back in the 16th century. It's referred to as the Statute of Elizabeth. And to wealthy families and business people, it's always a concern that the wealth that you built up and you've managed to accumulate and put into holding companies or investment companies. Well, we've made this point to you before. One of the reasons that a lot of you are intrigued by trust is because you've discovered that it's not good enough to hold it in your holding company because your corporate veil can get pierced. In some cases, your trusts can get broken. In some cases, you could lose your assets. If you've ever been involved with transactions that very, very innocently, you've moved money from an operating company up to a holding company, and you've had no reason for concern. Well, this, our friends, this is one reason why we have to be giving that whole issue a second thought, because the limited liability feature of a corporation is not always sufficient, in that if you've moved money from one company to another with an effort to hinder, delay, or defraud a creditor, according to this archaic legislation, well, that is a concern. And that's one reason some of you use trust. Another reason is you found out that some of the wealthiest people in the world use trusts to protect their assets. And think, okay, well, if it's good enough for individuals that are worth billions of dollars and they're doing it commonly around the world, well, that's something that you should do too. So anyway, just on to the next slide, Jeremy, if you please. So this is an individual that probably you've read about in the news. He was named the most eligible bachelor in Britain. This is Hugh Grosvenor VII. And of course, if you recall the story, this 7th Duke of Westminster inherited over $9 billion without any tax because of the use of trusts. So if some of you have been told, don't do trust because you're too young, because of the 21-year rule, because of the fact you'll lose control of your company, well, those are just small problems that need to be overcome through the effective and esoteric use of knowledge that can be deployed, which is not part of the building of the structure that your accountants and lawyers have often done for you and done very, very well. And we're not replacing that. Let's go on to the next slide, Jeremy. We'll talk a little bit about the history of this and some of the reasons that we consider trust to be good. Some people say, oh, I don't want to do anything aggressive. And what you'll learn shortly, as we'll have John and Lorne and Michael all talking about the history of trust and how trusts have been used effectively and not effectively, is that the backdrop for our legal system here in Canada, the tax system, deals with a specific issue, which is referred to today as GAR, General Anti-Avoidance Rules. And when we save tax, which trust can be used to do, it's important to understand that the fabric in which the GAR legislation exists was weaved upon the history of this particular ancestor of the other Duke I just shown you, the 7th Duke. Now we're talking about the 2nd Duke, who has the same namesake. So this individual will certainly, he used his ingenuity. He was able to pay a Gardiner by weekly installments rather than lump sum amounts, causing tax deductibility. Well, to quote Lord Tomlin, basically, you can hear this is, by the way, breath of fresh air here. Every man is entitled to order his affairs so that he's able to not pay the higher amount of tax, whether or not the tax authorities or his fellow man appreciate it. He has that right. So we're not suggesting for a minute that anything be done that's aggressive, but this is the backdrop for our legal system. Please move on to the next slide. And this gentleman, former Chief Justice Donald Bowman, has done more to promote the interests of equitability in tax than anyone else in the history of our country. Chief Justice Donald Bowman has presided over cases involving GAR issues and this whole entire argument of form over substance. He basically summed it up very nicely when he said, you know, you can dress up a cow to look like a horse, but it still is a cow. So what I'm suggesting to you is there's a certain level of fairness and equitability. And I had the good pleasure of interviewing Chief Justice Bowman, and actually gave me a course on litigation over a period of close to 200 hours. And he's worked very closely with our firm, but he's a tremendous advocate for what's right and what's fair. When it comes to bending the law, he did. When it comes to applying the law through malleability, he did. When it comes to elasticity, he did. But without understanding the metallurgical science, it's pretty hard to really be an expert in everything. No one knows everything. So we're suggesting to business owners, lawyers, and accountants, or tenants, that we're here to assist with some of these issues. So let's kick this off. Let's get things moving and talk about trust. I'd like to call on John McLeod to speak to us about the history of trust, if you please, John.
Certainly, Todd, thanks. And by the way, Todd, that was the first time I ever heard anybody say that trusts are sexy. And I've been involved in helping people around the world do trusts for over 25 years. So you've really improved everybody's outlook. Well, the concept of trust, first of all, what is a trust? A trust, as you can see, is a relationship that's recognized in law between one party called the settlor, who transfers the legal ownership of property of some sort to a second person or party, who's called the trustee. And the third party are known as the beneficiaries, those that have the benefit of the property that's been transferred to the trustee. Now, the history of trusts. Trust actually began back in the 11th and 12th century during the Crusades, when the knights of what is now England or the United Kingdom and Europe were off fighting the Crusades. And there was no guarantee they'd come back. But as landowners responsible for justice and tax collection and so on, they had duties and responsibilities, and they also had spouses and families and so on that they had to look after. So as they would leave and go to fight the holy wars, they would find a trusted person, which is where the concept of trust came from, transfer their title to that person who would administer the property on behalf of the beneficiaries in this case, the family or the kingdom or whatever it may be. And that worked famously well. And presumably, if the knight came back alive, the trustee would, or the trusted person then would transfer back to the original owner of the property. Well, that works really well when it works well, but we all know the story about Robin Hood and Prince John and so on, and sometimes it didn't work that well. So what came out of this were the rules of equity, and in fact, the concept of the courts of equity. The concept of trust, though, has evolved over the last almost 1,000 years, and in common law, and there's been substantial case law over the period, and it has become a very trusted concept and vehicle where there's a great deal of predictability. What's kind of interesting is that not only, and this is a common law concept, but what we're seeing is other jurisdictions such as civil law countries and Sharia law countries adopting the concept of trusts as well for the same reason. Almost 1,000 years of history and predictability. So that's a bit of background on the history and a bit of a background on what a trust is.
Yeah, that's perfect, John. Thank you. So let's just talk about trusts and say, are they really this about a foreign language? Are they really about a poorly spoken second language in tax that people are not accustomed to using about? Is it really something that you don't do? Is it something odd? Well, whenever you mail a letter, aren't you in effect establishing a trust? If you address an envelope, you put it in a mailbox. Well, Canada Trust has the carriage of it, but certainly not the individual who's entitled to receive the trust. So I'm giving you kind of a very crude, basic analogy to help you see that trusts are things we enter into all the time. Trusts are really an arrangement between you or a business person and their family. That's essentially what trusts are intended to do. We're going to move along here. We're going to talk a little bit about the parties to a trust at this point. And we're going to basically demonstrate what is the anatomy of a trust. And I'm wondering, Lorne Saltman, maybe just talk about the parties to a trust for us, please.
Sure, and I'll just follow up on what John was talking about, and then create perhaps some guideposts. The settlor is the party establishing the trust, the trust relationship, by making a gift of some kind of property. So one of the things we have to very carefully consider is who should be the settlor. And the reason we have to carefully consider that is because under the Income Tax Act, there are minefields called attribution rules. And if, for example, the settlor is a grandfather and the beneficiaries include minor grandchildren, and the settlor makes a gift that results in income that could benefit those grandchildren, the income will be attributed back to the grandfather. So instead of a grandfather, the recommendation would be that a friend of the family or a distant relative, ideally a non-resident of Canada, where the attribution rules don't extend to, should be the settlor. That's the first point. The second point is the initial property amount doesn't have to be a very large sum, tens of thousands. It could be, but doesn't have to be. And later on, we'll get into some larger figures, but just in the initial establishment of a trust, it can be a nominal amount. But the key is that whether it's shares of a company or cash, legal ownership is with the trustee. And that's a really important distinction because the trustee has a duty not to benefit himself, herself, or itself, but to administer the trust assets for the benefit of the other owner, the beneficial owners, the trustee, the beneficiaries. And typically, we create a trust where the gift by the settlor is irrevocable. So the settlor can't get back the property, can't get any benefit from income, loans back to the settlor, transfers, anything like that. It's an irrevocable gift, and the trustee is receiving the gift and holding it within what we call a discretionary trust, which means that no beneficiary has a fixed entitlement to an interest in the trust. Contrast that with a mutual fund trust that you might go into the market to acquire and buy 1% of the total trust fund. You know you have a fixed entitlement when you make that purchase for 1%. Here, the beneficiaries are all passive. They don't pay anything for their potential benefit, but I use the word potential because in a discretionary trust where they don't have a fixed entitlement, it's entirely up to the trustee to decide who gets a distribution, when, and how much. Now, the trustee has that discretion, and we refer to it in the trust documents, the deed of trust, as an absolute discretion, but we want to create accountability so that the family feels comfortable that the trustee is going to act in the best interests of the family. And there's a box in the top right called the protector. So typically in international trusts, not often in domestic Canadian trusts, but in international trusts, we have a position in the trust called the protector. It can be an individual, a company, or several. I often like to use a committee of protectors where it's majority rules. So the trustee under the deed is under an obligation to give prior notice to the protectors of a proposed distribution to a beneficiary. And the protectors, acting in the best interests of the family, and some of them could be family members, would confer with the trustee. And if the trustee is given the green light, the trustee then makes a distribution. But here's where the ultimate accountability lies. If the trustee is not acting in accordance with what the protectors believe should be the proper way in which the assets are administered, the deed of trust gives the protectors the power to remove the trustee and replace the trustee with another corporate trustee. And here's a very important distinction in terms of management and control, which I won't dwell on, I'll just touch on. But we understand that companies are resident in a particular jurisdiction based upon where management and control is effectively exercised. And often we look at who has the power at the shareholder level with voting common shares to elect a board of directors. Well, the Supreme Court of Canada a few years ago said the same rule should apply for trusts. So we want to determine who has effective management and control of the trust. When we set it up, the trustee is conferred with all of the powers necessary to administer the trust, and that's where management and control effectively lies. The beneficiaries don't control the trustee, and the protectors don't control the trustee. The fact that there's the power to remove the protectors, the power to remove the trustees, does not mean the protectors are in control. The trustee is still in control so long as it's in the position of being a trustee. So those are the key elements, with some of the important considerations for how we choose which parties to put into the trust. Back to you, Todd.
Oh, thank you, Lorne. Okay, so I would like to kind of take all of that highly technical information that we've been giving you, and we're going to step back for a moment, and we're putting it into a real life scenario. For those of you that have been attending our series on estate freezes, you're aware of the fact that we're able to freeze, cap, or limit the tax that's paid on death. And when we do that, we're also enabled to do some other quite incredible things. And that is, we can issue brand new shares of your company that have a very low value, a nominal value, perhaps $1 per share. Perhaps we issue 100 shares that have a value of $1 each. And we have a trust subscribe for these shares, meaning that after we've done an estate freeze, that all of the future growth would automatically be accrued to the trust. Now, when we talk about these various different parties to a trust, it's pretty important to understand that we get that you want to be in control of your company, or you lawyers and accountants would want your clients, the entrepreneurs that you work with, to maintain control of their own corporations. And by the way, that is not lost. When we set up trusts, we often look at questions, well, who should the trustee be? Who should the beneficiaries be? Well, really the most important question is, who are the beneficiaries? And the beneficiaries is the entrepreneur and the family members. And that includes future family members, children who are not yet born, grandchildren. See, what we're talking about is using trusts in order to achieve goals according to life's changing circumstances, including, but not limited to, the risk that one of our children will marry badly, or perhaps a grandchild. And if you give shares to them automatically, well, there is greater risk of you losing part of your company to a stranger. Being a beneficiary of a trust does not represent automatic entitlement to the shares of a company, as an example, or to the distribution of income, but it gives the right of discretion. The power of discretion is given to the trustees to decide who amongst the family members would receive the future growth of the company or the income, if any, and that would be decided. So you see, the level of flexibility that you achieve is not at the cost of control of your company. When we talk about using trustees, sometimes we'll suggest more than one, and generally we suggest three if it's a domestic trust in Canada. If it's a trust outside of Canada, and as many of you know, we do set up a lot of trusts outside of Canada. But the reality is that the trustees themselves are the ones who have the power of discretion during what we call the discretionary period to determine who amongst the family members, who amongst the beneficiaries receive the future growth of the company, if that's what you're using the trust for. The settler, well, is more of a ceremonial role, which is rather short-lived. Who would make a contribution of a financial nature, perhaps a $10 bill, in order to settle the trust, so that the trust, in effect, comes into existence. I noticed there's some hands being raised. Why don't we stop for a moment and hear some questions, Jeremy? I believe we had 2 or 3 hands that have gone up in the last few minutes. Okay, maybe I'm not sure if that's possible to achieve right now. We'll move on to the next slide then. So we're talking about roles of trustees, and what we've been talking about until now. It looks like we have Kevin who's wanting to make a comment. Kevin, go ahead, please. No? Okay. I'm not sure what happened there. We'll continue. This diagram presupposes that there may be different types of trusts. As I mentioned, as Lorne had mentioned, trusts outside of Canada sometimes have protectors, and sometimes we use corporate trustees. And John, maybe what we'll do is we'll have you talk a little bit about corporate trustees, since you're the chairman of Eticas International. But before we do that, I'll just say that some of the concerns that wealthy Canadians have can be solved by using trusts outside of Canada, not to take advantage of lower tax rates, but to create asset protection, to hold shares of companies in Canada. It can have a natural consequence to reduce capital gains taxes in some cases from 25% to 13.25%, but that's only a consequence of the asset protection planning that we're doing. Sometimes the the rate on passive income can be reduced from 50.13% down to 26.5%. When we use a trust purely as a holding instrument without ever sending any money outside of Canada, whether it's New Zealand or Barbados or the state of Wyoming or some other place, well, there's all sorts of possibilities with trusts where we can set up trusts without putting one penny ever at risk. John, maybe you could talk to us about the role of a corporate trustee in the context of a foreign trust, please.
Sure, happy to do so. A trustee has a duty in law to benefit only the beneficiaries and not themselves. In fact, most people don't realize this, but a trustee can't even be paid for services as a trustee unless he's entitled to charge his fees in a power granted in the trust deed or the declaration of trust. So trustees have a very high duty of responsibility to beneficiaries. And, just the same as in Canada, if you're a professional trustee, the ordinary man rule gets stretched beyond limits. So number one, trustees in almost every jurisdiction are regulated in the same way as they are in Canada. And it's usually a federal, but sometimes provincial or state regulator. In Barbados, where we do a lot of trusts for Canadians, there is the Ministry of International Business regulates trust and corporate services providers. In other jurisdictions, it's the central bank of the jurisdiction. And there's regular audits and responsibility, and it's, in other words, a trustee is, because of the huge responsibility and the control potentially of millions or billions of dollars worth of assets, have to be overseen very carefully, and are in fact. But if you look back through the case law, in most jurisdictions, you won't see very many examples of trustees, or at least professional trustees or corporate trustees, that have been taken to task for their actions.
Very good, very good. I think maybe we should hear from Michael Miller a little bit. It's often that when people set up trusts, they think of the Panama Papers, or they think of something terribly aggressive, which, by the way, we will never do. One of the concerns that people sometimes have when they set up trusts is they're concerned that their trust is located outside of Canada will be deemed to be a Canadian trust rather than a foreign trust, having the effect of losing some of the tax benefits that they were pursuing. Well, it's very important to understand that that kind of planning is aggressive, and it's not something we'd recommend. So when we talk about using a trust as a holding instrument, it presupposes that our trusts are Canadian trusts, no matter where in the world they're located. Therefore, they're taking away a big part of the target. Maybe Michael could talk to us about a famous case that's been used, the Gardiner case. Just give the audience a background, Michael, and tell them a little bit about what happened and why it's a problem.
Thanks, Todd. The Gardiner case, Garron, is also known as the Fundy Settlement in Canada case. It's a landmark Supreme Court of Canada case that was settled, ordered in 2012. So it's been around for 9 years. It's the leading case, and it's one that everyone follows now. In fact, more than just in Canada. So it starts off as an appeal from a federal court of Canada case. And the appellant is the trustee of the trust. And for this purpose, it was in Barbados for some wealthy Canadian families. The case stands for the premise that residency of the trustee does not necessarily mean that for tax purposes, it's the residency of the trust. So the case involved two families who set up trusts in Barbados, and that was for the benefit of Canadian residents as beneficiaries. And the facts of the case are that the trustee, which was a corporation in Barbados, sold some shares of that trust that were held in two Ontario corporations. The purchaser remitted to then the Minister of National Revenue, now CRA, $152 million for withholding tax on account of Canadian tax on the capital gains realized by the trust. So now the money goes to the Minister of National Revenue. The parties of the trust want that money back. It should have been paid there, they say. So they bring this case to court. And here's what happened. The court was asked to settle the issue and to decide was whether the trusts were resident in Canada for taxation purposes. And of course, the trustee says, no, I'm a trustee. I'm in Barbados. The trust is in Barbados. It's not a Canadian residency. But the court looked into this in some detail, and it ultimately dismissed the appeal, stating that the principal basis for imposing income tax in Canada is residency. In this case, the people in Canada made all the decisions, did all the controlling, the central management, everything related to the trust, and the trustee just carried out their instructions. The court held that that wasn't sufficient. The management and central control of the corporation rested in Canada, where the Canadians were set up the trust in the Barbados. So even if the trustee gives the trustee the power of control and management, if the actual control is in Canada by the beneficiaries, then the trust will be deemed a resident of Canada and governed by the Income Tax Act. And put it another way, if the trustee has the legal control, I believe Lorne brought up earlier about the trustee, if the trustee has the legal control, but does not have the operational control, then notwithstanding what the powers were granted to the trustee, the residency will be in Canada. So the bottom line is a factual test, and the court will be guided by the facts. Keep in mind, as Lorne said earlier, that the protectors can fire, I think it was Lorne, maybe it was you, John. You're both in front of the same trees, so hard to tell. But
Lorne is sitting at the other side of the bar, though. I'm on the left side of the bar. Lorne is on the right side of the bar.
it's funny, the wind is blowing the same way. In any event, keep in mind that the protectors of the Canadian settlers can fire the trustee at any time, but that will not be deemed to be central management and control. So that's the residency. Just setting it up in a foreign jurisdiction does not mean the Canadian government and under the Income Tax Act are going to accept that as where the true residency is.
Lorne, maybe, oh, sorry, go ahead, Michael. Yeah.
No, I was just saying your name.
Oh, I see. Okay,
You,
thank you. So Lorne, maybe I'll just invite you back onto the platform for a moment. And as you're reapproaching us, I'm going to just point out that when we use trusts as I called them, holding instruments previously, that would hold the shares of an investment company, there's all sorts of different benefits. And maybe I could ask you to discuss the way that this would work. And before you do that, I'm going to maybe call up a diagram that will give rise to this kind of a structure, because here we have a holding company, and in this particular case, it's our goal that the holding company would be controlled by these 100 common shares held by the trust. It's to be presumed that there's no small business deduction or capital gains exemption, that we're essentially using this structure in order to create foreign control of the company in order to create asset protection. We understand that there's different parties here. We have trustees and we have beneficiaries, and we also have protectors that aren't on the slide. And what we're saying is, number one, it's great that Barbados, in this case, if it is Barbados, has a tax rate from 5% down to 1.5%, but that is irrelevant. We're not utilizing the tax rates. We're paying tax in Canada on all assets. The trust itself is filing a T3 return. Lorne, can you speak to us about what's going on here, please?
Yeah, this is actually a very simple diagram. This doesn't give us the full picture of the estate freeze. But what I want, okay.
Sorry, Lorne. There we go. Here we go.
Yeah, okay. This gives a better depiction. It's a little more complicated, but start with the left, typical opco with active assets in Canada, owned by a typical holdco in Canada. And what we want to do is achieve superior asset protection for the owner of holdco, being the entrepreneur, and ultimately his family members, the beneficiaries, children, grandchildren, etc. That's the primary goal, superior asset protection. And we're going to choose a jurisdiction customized to the particular family's needs. And we've done it in different jurisdictions. We like Barbados, but Wyoming in the US for families that have US beneficiaries might be more palatable. We would customize. The key is that it's not a trust resident in Canada, but the trustee having effective management and control exercises that from the foreign jurisdiction. Okay, so that's the trust element. And then we've got this investco on the side. How does all this fit together? Well, we want the existing structure, the holdco and the opco, to be protected in terms of availability for the tax benefits that accrue to a Canadian-controlled private company. And so if opco earns income from an active business carried on here, the first $500,000 could be subject to the low tax rate of 12.5%. And if the shares of holdco were qualified small business corporation shares on actual sale or deemed disposition, there could be the lifetime capital gains exemption available to one or more owners of those shares. And we have to be very careful about how we maintain, how we create to begin with, and then maintain the status of these shares as qualified small business corporation shares. Without going into too much detail, we just want to make sure that 90% of the fair market value of the holdco shares is attributable to assets used or held in carrying on an active business in Canada by the combination of holdco and opco. And it's a look back for 24 months prior to the disposition, actual or deemed, as well as at the time of the disposition. So in our structure, the entrepreneur, starting with common shares, exchanges them on a tax-deferred rollover basis for fixed value preference shares with a redemption amount, the fair market value equal to what the common shares of the holding company are worth, plus a class of nominal value but super voting shares, so that now we are comfortable that holdco and opco are controlled by the entrepreneur through the super voting shares. We want to be able to maintain that 90% test throughout. And what if we have excess of cash or other assets? How can we purify holdco opco? That's where investco comes in. So holdco issues two classes of shares. The Class B common shares are issued to investco, entitling the holder to dividends only, but no entitlement on liquidation. So there's no capital growth that accrues in the common Class B common shares. Instead, the Class A common shares going directly up to the foreign trust entitle the holder only to liquidation entitlement, but no dividends. So all the growth goes on the Class A common to the foreign trust, none of the dividend entitlement. The opposite, all of the dividend entitlement goes to the investco with no liquidation entitlement. So now if holdco opco generates excess surplus, we pay it on it by way of a dividend from the holdco to the investco, and it can be received tax-free because they're all part of a related group. Now let's say that the entrepreneur has a portfolio of investments, which in his or her hands would be taxed on ordinary income at 53% and on capital gains at 26.5%. If we were to transfer that portfolio let's say under a tax deferred rollover, section 85, we could take back shares from Invesco, let's call them non-voting preferred shares. So the common shares of Invesco are owned by the foreign trust, giving it control. Non-voting shares of value equal to the portfolio would be in the hands of the entrepreneur. So what do we accomplish by that kind of arrangement? Well, as I mentioned, we've been able to put surplus from the left side, the active companies, over to the passive side on the right, and we've put personal investment assets into the Invesco. That Invesco is not a Canadian controlled private company. It is a company that is controlled by the foreign trust. Under the very special tax rules for non-resident trusts, the so-called NERT rules, that foreign trust, because it owns shares in Canadian companies, will be deemed to be resident in Canada for purposes of specific purposes, including computing worldwide income. And so it will file a T3 tax return and be fully compliant as though it's an Ontario trust. But it is still located in, let's say, Barbados or Wyoming, where management and control is effectively exercised. So it is a foreign owner. And if it has voting control, Invesco is a company not controlled by residents of Canada, but by a non-resident. Even though the beneficiaries of the trust are residents of Canada, they're not in control. They are passive members of the discretionary class. And the result for Invesco is we have reduced the tax rate on that investment income by 1/2. So ordinary income is taxed not in a CCPC situation, 50.2%. Instead, it's 26.5%. And for capital gains, instead of 26.5%, it's 13.25%. And so overall, what's the result of all this complicated structure? We accomplish an estate freeze because the entrepreneur has frozen preference shares. We maintain the ability to claim the small business deduction and get the lifetime capital gains exemption for the holdco-opco structure. And I might mention, if a purchaser comes along to buy the holdco-opco structure, and there is a capital growth on the Class A common shares that accrue to the foreign trust, it's the trustee that will be the seller of the shares, realizing a capital gain, and the Income Tax Act permits that under a proper compliant allocation, the capital gains can be allocated to one or more beneficiaries along with the capital gains exemption. So if there's a family with, let's say, 3 adult children, the capital gains exemption this year is about $890,000, almost $1 million. Times 3, we saved $3 million in tax on the capital gains. It can be a very significant benefit for a future sale. And the other part that's very important is the use of Invesco to be able to accumulate the surplus taxed at half rates owned by a trust in a jurisdiction with superior asset protection. And so the shares of all these companies, the Holdco has issued shares, the Invesco has issued shares, those shares are protected for the family's benefit because they're held by the trust in the jurisdiction that has superior asset protection to Ontario. Back to you, Todd.
Well, thank you, Lorne. So let's just again take another glance at this from another perspective and say, how does this apply in your individual company? What are the perils? What are the concerns? What are the things you need to do to start protecting yourself? Because one thing that many people don't realize, if you are the shareholder of your own holding company and you do not have a trust, your entire empire could disappear very quickly. If someone was to sue you personally, they'll take the shares of your company as they will any other assets. Now, if we drill down, and I did a lecture at the Ontario Bar Association, Lorne, myself, and former Chief Justice Bowman, who I referred to earlier. And one of the questions that I was asking some of the lawyers in attendance is, how do you basically prevent some of these issues and how do you provide for the tax effective transfer to the next generation. And we got some peculiar answers that I'll talk about, which are excellent, but I'll also talk about some ones that are not peculiar. So what is common? And that's one really interesting question. And I would suggest for a moment that what is common, and when I say peculiar, I mean things that we don't run into every day, which are amazing ideas, but I'm talking about more common things that we see happening on a day-to-day basis. So one of the realities is when an operating company starts to build up cash and it decides to creditor proof or provide asset protection by moving the cash up to the holding company, we often see large amounts of cash stuck inside of the holding company. So when I asked the group, what are you doing to provide for the tax effective transfer? I said, do you ever look underneath the share? And so the question was, well, what does that mean? Well, if you bought a car, wouldn't you look under the hood before you bought it? Well, when we're looking at the shares, it's very interesting to see that there's millions of dollars of cash sitting in the holding company. Well, has anyone stopped to think about that, to say, does that cash mean that we've lost the capital gains exemption? Is that possible? Well, Lorne had referred to purification. Purification refers to the removal of surplus cash in order for the shares of the company to become eligible. You see, at the time of sale, and Lorne mentioned two things. He mentioned the 24-month period, and he mentioned at the time of disposition, but at the time that you sell, the time that you die, the time that you transfer, all or substantially all of the value of the company ought to be actively used. And if you have stacked companies, that means OpCo, HoldCo. Forget about 50%, it's 90%. So if you have 10 million in cash, you better have 100 million of other active assets. Otherwise, you're possibly facing the loss of a capital gains exemption. I'd also mention that the cash that you've moved from OpCo to HoldCo can be attacked. If OpCo is assessed for some reason, and CRA is assessing companies for all sorts of reasons, and you've previously moved $10 million over periods of years from OpCo to HoldCo, CRA can apply section 160 in order to essentially take the money from HoldCo. So one of the benefits we have when we set up foreign trusts is that whoever wants the money, if we're talking about funds that have been transferred without any tax from HoldCo to Investco tax-free, well, if anybody wants to attach that money, they're going to be going, say, to Barbados to try to get it. Well, there's lots of things that we can say about that. But before we do, I'd like to hear what John McLeod would have to say as a trustee, where there's a claim, perhaps liability or under the Family Law Act. John, what happens in those situations?
Well, the trustee would have to entertain a claim if it were in Barbados, and it varies jurisdiction by jurisdiction. But there are some interesting, in Barbados, for example, within the trust legislation, there's a 3-year statute of limitations. So after 3 years, the courts won't even hear the action. So there's a statute of limitations in Cayman, which I think is 6 years, and it varies jurisdiction by jurisdiction. But the reality is the court in Barbados will receive a judgment from an Ontario court or a Canadian court, I should say, of any sort. And it'll say, well, gee, we understand your position. However, we only have jurisdiction over Barbados assets. And the asset held in this trust is a Canadian corporation. So we can't fulfill your judgment because we have no control over that Canadian asset. And that's why asset protection jurisdictions are selected to be the situs for international trusts.
And I can add one
protection of all of the reasons why people use trusts today. Asset protection is usually very near the top.
I would add to that. It's because it's a discretionary trust. One of the beneficiaries may choose to sue because they want some money from the trust that the trustee is not giving her or him, and the courts give the same answer in Barbados, that because they don't hold the assets there, that there's no claim.
Well, I was more thinking of a third party, okay? So say as an example that the entrepreneur's grandchild or child, say the child marries badly and ends up that they decide to sue because they were promised the moon and the stars and they work 7 days a week, 12 hours a day in the business. Whether those things are true or not, who knows? But they were promised some sort of partnership or ownership in the company. And then all of a sudden, when people marriages break up, well, sometimes honesty isn't the highest priority too. And sometimes we've seen situations where in Canada, where the courts have applied the Fraudulent Conveyances Act, can have the effect of piercing a corporate veil or breaking a trust in some situations. But in the event that it was in Barbados, it provides this extra level of protection since they do not have the kind of legislation that we have here that presupposes that we have to be concerned about things like hindering and delaying a creditor, not whether it's an existing creditor, but it's also whether it's a future creditor. Now, in those events, Michael, tell us about reciprocal enforcement in Barbados. So say somebody has a court order from the province of Ontario and they go to Barbados and there's no assets there. There's only shares of a company in Ontario. What's the result?
The person bringing it to Barbados loses.
Okay, that's good. So I think that this is, pretty much an idea on one of the usages of a trust, but there's so many others that we want to talk about. I know there's a lot of different questions coming in. Maybe what we should do is just shift gears for the last few minutes. We will be taking questions at 1 o'clock. One of the things I want to talk a little bit about is well-meaning advisors who tell their client they're too young to do an estate freeze, too young to use a trust, too young to do this kind of planning, because in 21 years, the trust has to dispose of the assets. Well, the good news is for all of those in attendance that there are remedies for the problem. One of the simple remedies here is a refreeze, which would involve the transfer of the conversion of common shares for preferred shares, having the effect that we have a new trust that would essentially be effective for an additional 21-year period, providing there's a refreeze. There's GAR issues that we have to deal with. Again, it's kind of like that finite element analysis and saying, how can it be done? Well, if you're not an expert in metallurgical science, you don't know how far to bend it before it breaks. And you're certainly not going to risk your wealth upon it happening, but knowing how to resolve that is another issue. Lorne, there's a slide here that I'll have you speak to. Keep in mind, we have 3 minutes to close the program, and we're just doing a very brief recap on some of the points that have been missed. Lorne, can you talk about holding a U.S. property by a trust?
Sure. We're often asked by clients, they want to buy a Florida vacation home. Should they use an Ontario company to buy it? Should they do it personally? What we recommend is a trust, a family trust. And let's say one spouse, it could be the husband or the wife, with funding, acts as a settlor and can settle a trust on the other spouse. It could be the spouse as an individual, or I'm setting one up now with one of the Canadian trust companies as the corporate trustee. Works equally well because it's here in Canada, or the husband or wife would be here in Canada. So Canadian trust for the benefit of the children, and a spouse could be included as a beneficiary as well. Why do we use a trust? Because when we're looking at exposure to US tax, we are particularly concerned with real estate about US estate tax, because on death, the US will impose up to a 40% tax on the gross value of real property owned by, let's say, Canadian resident over, I think it's over $1.5 million US. And so it's a very draconian tax that we try to avoid by creating an insulation, and a family trust is such a tool because from a US point of view, neither spouse owns the asset at the date of death. The trust is respected, and if the property is sold before death, the capital gain that's realized is allocated to the individual beneficiaries. And in the US, The tax rate on capital gains is quite low, comparable to what we hear in Canada, even if under the new Democratic administration, the tax rates will go up. It'll still be in the low 20s, and it'll be that tax will be available as a foreign tax credit against Canadian taxes payable. So we don't have double taxation, but we do have insulation from U.S. estate tax. Back to you, Todd.
Thank you, Lorne. So it's 1 o'clock and we're going to open up the questions. And as we're getting organized to deal with the questions, maybe I'll have John McLeod just address how individuals who remain in the motherland, and we have younger generations that decide to come to Canada, how they can transfer property without the effects of tax using a granny trust. Maybe just give a brief idea about that as we start organizing the questions. As soon as John's finished, we're going to talk, we're going to open the floor and hopefully answer all your questions. John, just maybe give a brief description of a granny trust.
Absolutely, Todd. Not only inbound trusts such as granny trusts, but similarly outbound trusts. For example, if a family member is moving from Canada to the United Kingdom, they're going from a high tax jurisdiction to a high tax jurisdiction. If we structure the thing correctly, we can let them live in the United Kingdom for 8 years tax-free. But a granny trust is probably one of the few remaining opportunities for new immigrants to Canada, whereby if there is a foreign settlor and contributor that forms a foreign trust whose beneficiaries are residents of Canada, provided that the Canadian residents receive or are entitled only to distributions of capital, Canada will not seek to tax the capital distribution, nor will Canada seek to tax the trust. So if Granny remains in Hong Kong and the rest of the family moves to Canada, then during the children's generation and the grandchildren's generation, as long as they receive distributions of clean capital, there will be no income tax on the growth in the trust.
Excellent. Okay, so as we're just wrapping things up here, we'd like to announce our next webinar, which will be on tax disputes and litigation. Emergency wage subsidy has become an issue. We've been assisting companies in Canada with dealing with CRA, giving assistance and then asking for it back. Also non-CCPC tax disputes, and also various different disputes that companies are being confronted with. So we're here to help with that. That'll be on Wednesday, April the 14th. Thank you very much to our expert panel. Let's open up the questions now. So first of all, we have a question here that asks about the minimum value of an estate where one would consider setting up a foreign trust rather than a domestic trust, say an Ontario trust or British Columbia trust. Maybe Lorne, what would your view be of the minimum value of an estate that someone should use before setting up a trust here in outside of Canada?
Probably in the range of $5 million, I would say, for the value of the company that's being frozen. Keeping in mind that the trust acquires nominal value shares, and we're looking for growth in value on those common shares. But there are going to be costs of establishing it, the legal fees, the trustee fees, and maintaining it. So probably in the range of $5 million for the business is a round figure to consider.
Excellent. Another question is, gentleman curious as to why you would not have the trust directly owning OpCo. And that's a good question, actually. Instead of HoldCo, to make it easier to claim capital gains exemptions on the future. Well, this is Jeremy is saying here, would like to, okay, so here we have it. Jeremy, did you have, would you like to bring on this individual to ask the question? I'm just getting a note here.
No, Todd.
Okay.
Just go ahead and answer it. Thank you.
Oh, so I would agree with this very perceptive individual. I don't like unnecessary complexity. I don't like unnecessary companies, and I don't like things that are, just an extra tax return to file, an extra financial statement to prepare. And certainly I don't like making it harder for the shareholders to claim capital gains exemptions because we have the anti-stacking rules. So the answer is we often find that when we come along. Oftentimes, when we talk about these builders of structures and so on that have set up good planning, but sometimes it is an opco holdco structure we find when we come along. And we say, well, how do we deal with it from there? We'll go on to the next question. In terms of creditor protection, does a trust offer any protection against the CRA? For instance, has the CRA been known to garnish disbursements to trusts or to beneficiaries? Lorne, do you want to answer that?
And the CRA in this context is like any other creditor trying to attack the beneficiaries of a discretionary trust. Keeping in mind, none of the beneficiaries has control over the trust assets, which are the shares of the frozen companies and the Investco. So the asset protection arrangement that we're creating should provide insulation against that creditor as well.
If I could just jump in and add something there as well. The same would apply for inheritance taxes. So many of our clients over the years have owned property in the UK or the United States and so on. And if the asset is held in a trust, it will shelter any estate or inheritance taxes as well.
Yeah.
Excellent. We have a question. We have a non-resident of Canada who wants to purchase commercial property in Canada. Now, presumably the commercial property that he's purchasing, I'm thinking as I'm reading this, would be rental property or investment property that would yield a return. It says to get lending would be ideal to be a CCPC. Can a trust somehow achieve a CCPC status for a Canadian corp held by this non-resident? Well, I'm going to start off this answer by saying that I'm not so sure you'd want that because of the fact that Canadian controlled private corporation, first of all, is subject to federal refundable tax or surtax, which would have the effect of your rental income being at over 50% and your capital gains at being 25% versus a lower rate. Notwithstanding that, would John or Lorne like to take a run at that? Michael?
We have set up structures over the last few years for non-residents from all over the world who are interested in Canadian real estate, multi-residential properties and so on. And working with John McLeod and his company, Eticas in Barbados, we have invested through a Barbados company, and the investors can use a Barbados trust to hold their shares in the Barbados company. But the key is that that Barbados company, generally through a limited partnership, acquires the Canadian real estate and will be subject to Canadian tax on sale. But because it's a non-resident corporation, it is not a CCPC. The tax on the capital gain is the half rate applicable. So it's 13.25%. That would be the ideal structure for a non-resident wanting to acquire an interest in Canadian real estate.
Yeah, I would say that in general, you know, the whole concept of inbound investment is a very interesting discussion. And one of the things that we've been successful in doing is aggregating investors through collective investment arrangements that can result in individuals subscribing for shares in a corporation in Barbados that would act as a limited partner to a limited partnership in Canada, which in some cases can have the effect of creating incredible commercial sensibility. At the same time, we create divisions of assets and liabilities. Each class of shares are separate and distinct from each other. There's so many things that can be done, and where it works the best is where we're using a trust in order to facilitate this. In some instances, there's benefits where there's investments into opportunities where the property does not generate tax in Canada, and the investment return is such that it's not necessarily taxed in another jurisdiction. And there's things that we've done in the past as far as moving exempt surplus in Canadian tax terms into Canada by holding shares of companies and having the withholding tax from another corporation, the US, taxed at a much lower rate. Exempt surplus presumes that the tax has already been paid in the local jurisdiction and therefore is not subject to double tax where there's a treaty or an information exchange agreement between countries. There's too many questions to answer. We're talking about our very favorite subject, and that's tax. We could go on and on. We're looking forward to seeing all of you back. When is this date of this next event, Jeremy? Oh, seems like,
On Wednesday, April the 14th.
okay. Until then, we wish all of you a very pleasant spring afternoon.